Hello, everyone, and welcome to today's session on one of the most important yet ignored aspects of building a startup in India: intellectual property rights, or IPR, for startups. Now, most often, many startups they usually focus on funding, uh, marketing, product development, hiring teams, scaling options, etc. But they often forget the single most valuable asset of their business: their intellectual property. Today, startups are not valued only based on revenue. Investors often evaluate startups based on their brand value, technology ownership, patents, trademarks, copyright ownership, trade secrets, software ownership, proprietary database. In this session, we will discuss what exactly is IPR, what are the different kinds of intellectual property rights relevant for startups, important Indian laws governing IPR, trademark protection for startups, copyright ownership issues, patent and tech startups, founder disputes involving the IPR, employee and freelance ownership issues. What happens if the founder fails to transfer IP to the startup? What are real world IP disputes and different case studies? What exactly is investor due diligence and IP ownership? What are the best practices for a startup founder? Now, this session is for you if you are a startup founder, law student, content creator, or an entrepreneur. So, let us begin by understanding what exactly is the meaning of intellectual property. Intellectual property usually refers to the creations of human mind. Example: your brand name, your logos, software, uh, mobile application, website content, designs, music, technology, inventions, product formulas, and marketing material. Now, IPR gives legal protection to these creations. In India, the major IPR laws include your Copyright Act, Trademark Act, Patent Act, and the Designs Act. For startups, IP often is the biggest business asset. For example, the logo of Zomato or the brand name of Nika itself carries enormous commercial value. Now, why exactly is IPR important for startup? IPR is important because it usually helps startups to protect the brand identity, prevent copying, attracts investors, increase valuation. It creates licensing opportunities, it builds customer trust, and it helps you gain a competitive advantage. Now, imagine building a successful startup and later discovering that someone else owns your trademark. Or imagine a founder leaving the company and claiming the ownership of the startup software code. This happens more often than people realize. Investors today are conducting extensive IP due diligence before investing. So, a weak IP ownership can usually destroy your funding opportunities. Let's move on to the trademark protection for startups. So, what exactly does a trademark protect for a startup? It protects the brand names, logos, your taglines, your product names, and these are governed under the Trademarks Act 1999. Every startup should ideally trademark their company name, their product name, their logo, app name, podcast, or platform names. For example, the names Paytm, Flipkart, Boat are very valuable trademarks. So let's talk about one case study that is about a startup brand dispute. Now, many startups face legal notices because they fail to conduct trademark searches before launching. Imagine you're spending lakhs of rupees on marketing only to receive a trademark infringement notice later. Now, trademark infringement may lead to injunctions, damages, rebranding costs, and loss of goodwill. That is why trademark clearance searches are essential before launching a startup. Let's talk about copyright protection for startup. So, copyright is something that usually protects your software code, website content, designs, videos, marketing material, articles, your training material, and your UI UX elements. It is usually governed under the Copyright Act 1957. One major issue in startups is the ownership confusion. For example, if a freelancer develops an app, that is your company startup's app, and if there is no written agreement assigning the copyright to the startup, the developer may legally claim ownership. This creates major investor risk. Let's move on to the founder failing to transfer IPR to the startup. This is one of the most common cases that I have dealt with, wherein one founder exits and boom, there's a huge clash. This is one of the biggest mistakes that is made by Indian startups. Many founders usually register their trademarks in their personal names. They build software personally, file patents individually, and use personal ownership structures. Later, during funding rounds or acquisition, investors discover that the startup itself does not own the IP. Now, this creates a serious problem. What happens legally? If IP is not assigned to the startup, the founder may remain the legal owner. Investors may refuse funding, acquisitions may fail, co founder disputes may arise, and employee ownership claims may emerge. For example, let's say two founders together build a SaaS company. One founder develops the code personally and never assigns the assignment agreement. Later, after disputes, the founder leaves and the claims ownership of the software. The startup may lose product ownership, investor confidence, and commercial rights. This has happened globally in multiple startup disputes. Let's talk about investor due diligence. What exactly does the investor ask? Who owns the IP? Are the assignment agreements signed? Are employee contracts executed? Are freelancers assigning copyright? Improper IP ownership is a major red flag during the funding. Let's talk about the patent protection for startup. What exactly is the importance of patent? So your patents protect your inventions and it is governed by the Patents Act 1970. Tech startups may patent their hardware systems, AI innovations, manufacturing process, medical devices, or your technical solution. However, not all softwares are patentable in India. India restricts patentability of software per se. Let's go and listen to an interesting case study of pharma and tech patent battles. Now, Indian startup ecosystem have seen multiple patent disputes involving pharmaceutical innovation, deep tech companies, hardware manufacturing, biotechnology startup. Patent litigation is expensive but commercially significant. Trade secrets and confidentiality. Now, not everything needs to be patented. Some startups protect information through trade secrets. For example, your algorithms, customer database, marketing strategy, pricing models, formulas. Trade secrets are protected primarily through NDAs, employment agreement, and confidentiality clauses. For example, the recipe of Coca Cola is globally protected as a trade secret. Let's talk about employee and freelance IPR issues. Many startup founders outsource their work to freelancers, agencies, consultants, developers, designers without written agreements. Now, a startup may not legally own a code, design, branding, or marketing material. And therefore, every startup has to mandatorily execute employment agreement, freelancer agreement, IP assignment agreement, and confidentiality agreements. Let's move on to startup IPR infringement case studies. Let's talk about trademark similarity. Many Indian startups have received notices from established brands for deceptively similar names. So, what exactly does the court examine? Consumer confusion, similarity of marks, and business category overlap. Moving on to copyright disputes, content based startups often face disputes involving unauthorized use of images, music infringement, copying website content, pirated educational material. Let's talk about co founder IP disputes. Now, globally, several startups have collapsed because of co founders have fought over the ownership of technology and source code. And that is why your legal documentation, having correct legal documentation right from day one, is very critical. let's talk about the best practices for startups. So, in order to have a smooth startup functioning, every startup should register a trademark early, execute founder agreements, sign IP assignment agreements. You need to protect your confidential information, conduct trademark searches thoroughly before even you begin your business, use NDA with employees and vendors, audit ownership of software and branding, maintain proper documentation. You need to protect your domain names and digital asset. IPR should not be treated as an afterthought. It should become a part of the startup strategy itself. To conclude, intellectual property is often the most valuable asset of a startup. Today, startups are not only competing through products, but also through branding, innovation, technology ownership, content, data, and consumer trust. Ignoring IP protection can result in investor rejection, costly litigation, founder dispute, and loss of business ownership itself. Whether you're building a tech startup, a D2C brand, a SaaS company, a content platform, or an AI company, understanding IPR is absolutely essential. Strong IP governance helps startup to raise investment, scale globally, prevent copying, and build long-term enterprise value. Thank you everyone for joining this session, and I hope this helped you understand the importance of intellectual property rights for startups in India. Do like, subscribe, and follow.